Colorado's law restricts licensed therapists' ability to offer conversion therapy, which the state defines to mean treatment that is provided in clinical settings that is aimed at altering an individual's behavior. So this would be therapy that involves telling someone who's gay that actually they're attracted to people of the opposite sex, or telling someone who is trans that actually they are cis.
But the plaintiff in Childs insists that she doesn't want to change someone's behavior or identity or orientation. At most, she wants to be able to talk about sexual orientation and gender identity, which she says might include counseling someone to cope with the sexual orientation or gender identity that is causing them stress. So it's not clear that what she wants to do is even prohibited under the statute. That would mean the law wouldn't and couldn't be enforced against her, which would mean she doesn't have standing to challenge the law.
But all of that, of course, assumes that the law is real and the court honors and observes it. But really, why let jurisdiction get in the way of a good time if you are poised to axe some state law on an ostensible First Amendment theory? So the plaintiffs' lawyers here, the Alliance Defending Freedom, who are the same team behind 303 Creative versus Elenis, which we were just talking about, says that Colorado's law hurts patients who come in wanting conversion therapy. Apparently, this is all based on anonymous Reddit posts.
Much good evidence is based on
most of it,
Reddit
I would
posts.
even say. But none of those posters actually challenge this law. So that leaves ADF with a therapist whose conduct probably isn't prohibited by the statute, who's challenging a statute that hasn't been enforced for 6 years, as Justice Sotomayor pointed out in the oral argument. And basically, the plaintiff's standing argument amounts to claiming she is afraid the law will be enforced and that this fear is chilling her conduct. The lawyers also say, but we think the statute does prohibit the conduct she wants to engage in, even though the state insists that it does not.
TLDR, standing is also now for suckers. Because the justices apparently feel free to adjudicate any case seeking to vindicate right-wing culture war grievances, the court barely engaged with these jurisdictional niceties, aside from Justices Gorsuch and Barrett kind of poo-pooing them.